Good afternoon. My name's Anthony Licatesi. I am a member of the Licatesi Law Group and speaking today on New York State's no-fault laws. And speaking as well is Michael Licatesi, also a member of the firm, and we'll be dividing up the curriculum a little bit and giving a perspective really from the claimant's perspective and New York State's no fault. The Comprehensive Motor Vehicle Insurance Reparations Act was passed in February of 1974, and it's known today as New York State no fault law. And the brief history of that is our court system was burdened in the 60s and 70s with car accident cases, and at that time there was what we call no serious injury threshold. So anyone could start a lawsuit for any particular reason prior to the no fault regulation being enacted, which we call Regulation 68. And the site on that is 11 NYCRR 65. So to unburden our court system from all of these less than serious car accident cases, the quid pro quo was, let's pass the no-fault laws, or this Comprehensive Motor Vehicle Insurance Reparations Act, to compensate and provide prompt payment of medical expenses and lost wages to eligible injured parties, or referred to as EIPs. The host vehicle carries the no-fault insurance. So if you're, in a vehicle as a driver or passenger, that vehicle, regardless of fault, the insurance carrier for that particular automobile will be obligated to pay those no-fault expenses that are related to that car accident. So again, to give a brief history, the consumer advocate groups were up in arms. Ralph Nader and those groups, they objected to giving up an essential constitutional right for every New York State resident to be able to sue, whether it was a sprain or, a minor injury. And they felt that the quid pro quo, that don't worry, we'll pay all of the related medical expenses and lost wages, that it wasn't going to be enough, that insurance carriers were not going to promptly and expeditiously pay for those payments. It was prophetic. They couldn't have been more correct because, and again, this is a claimant's perspective, we have found that insurance carriers in this no-fault area routinely deny claims, and probably the voluntary pay, although I don't have statistics on it, is absolutely below the normal when it comes to other forms of healthcare reimbursement, such as major medical and other expenses where voluntary pays are much higher than in the no-fault system. The legislature said, again, to the consumer advocate groups, do not worry. We're going to put some teeth or some bite into the regulation. And part of the bite or the teeth into the regulation is that if no-fault benefits are wrongfully denied, there will be a penalty assessed to the insurance carrier of 2% a month in interest. Now, if you think about that, most of us get less than 2% annually right now. It's probably less than 1%. 2% a month or 24% annually is a pretty hefty, let's say, penalty to the insurance carrier. And also, in addition thereto, there was a penalty of attorney fees. So if we, as a claimant law firm that specializes in no-fault collections, if we go in and are successful in the payment of a claim, which we are like probably about 90% of the time, maybe even mid 90 percentile, depending on the claims that we go into to get reimbursed to the healthcare providers. We also get a legal fee that's assessed, that's paid directly from the insurance carrier to the law firm, as well as the reimbursement of the filing fee. So there was some teeth and some, ammunition there to try to dissuade no-fault insurance carriers from wrongfully denying these claims. When I started in this area of law, I started as a respondent or a defense attorney 34 years ago. The name of the carrier then was General Insurance, General Accident Insurance Company. They've since were bought out and merged with other companies. But as I sat during those hearings and lost case after case, I was like, well, maybe there really is some truth to this being a healthcare provider or EIP, an eligible injured person, dedicated system where they really want to make the insurance carriers provide the coverage that is mandated by New York state law and not wrongfully deny. So I quickly, early on in my career, turned to the applicant side and started filing these cases on behalf of healthcare providers, whether they're, orthopedics or neurologists, radiologists, even providers of medicines and durable goods and supplies that go out. They're all entitled to be reimbursed, most of which under a fee schedule, for anything that's reasonable and necessary and related to the car accident. So with that, there are a few forms that every healthcare provider should be giving their patients, the EIP, the eligible injured party. One of them is an assignment of benefits that assigns those benefits to the healthcare provider. The healthcare provider then stands in the shoes of that assignor and provides those invoices to the insurance company. A history of this regulation shows that there were various amendments throughout the years. And I think it was really the knee-jerk reaction. There was a widespread area of fraud in the late 1990s. And the knee-jerk reaction to that fraud was, let's fight it through the regulation. And they started to reduce some of the filing periods for a healthcare provider or an EIP to submit claims. Traditionally, when the law was passed, there was a 90-day period to file a no-fault application or an NF2. And there was also 180 days from the last date of treatment to submit bills to the insurance carrier. So to reduce these periods, they felt would reduce the amount of abuse to the insurance carriers. And again, I remind the audience that this is a claimant's perspective. It used to be called the New York State Insurance Department. It's now known as the Department of Financial Services. As applicants and claimants, we don't get much help from that particular government entity. Most of the amendments are very pro-insurance carrier that have occurred over the years. I think that the Department of Financial Services and its predecessor, the New York State Insurance Department, lost sight of the legislative intent, which was to expeditiously provide benefits, whether they were medical or lost wages, to eligible injured parties. One of the areas that's most egregious when insurance carriers do not promptly and expeditiously provide these benefits is if you're injured and you're the moneymaker and you're the provider of a household, and there's expenses and set aside just rent or food, mortgage payments. An insurance carrier's reluctance to promptly or expeditiously pay these payments could result in some traumatic results and consequences, such as foreclosure and ruining credit histories. And I've seen it in 34 years, the results of this. So there is a box now that you can check off when you're filing for a no-fault arbitration, which is what we do. We file arbitrations. We can also file them in civil court for any unpaid no-fault claims. But there is a box now that you can check to expedite if there are lost wages or if something has been denied within 30 days. So the New York State Insurance Department, or DFS, known now as DFS, has kind of heard some of the outcries from the New York State residents in helping to expedite these payments, again, in accordance with the initial legislative intent from the 1970s. So when we do, file these expedited, we're normally heard within 3 or 4 months. Right now, when we file an arbitration, I think the wait is probably 12 to 14 months. So that is a little bit of a history, but let me go back to the 90 days and the 180 days. It is now currently 30 days to file an NF2 or a no-fault application, and the 180 was reduced to 45 days, which really is a short amount of time to file an invoice from the last date of treatment. You can consider when you have now slightly over a month, and it used to be 6 months, a huge difference in terms of filing. What they did put in, and I believe that was 2001, 2002, and it was an uproar. I mean, there were court cases that were filed. It was challenged in New York State Supreme Court. There was a stay. It went up to appellate divisions, and ultimately the regulation was changed, and those amendments were made and ruled by our court system that they were, in fact, legal and effective. So the 30 days is there, but the quid pro quo on that was that if there's a reasonable excuse for not filing within the 30 days, that the 30 days would be extended. So an example of a reasonable excuse, let's say I was in a car accident. Let's say I was a pedestrian, and I'm struck by a car and I'm in the hospital, and I have no idea of the no-fault insurance information of that host vehicle that struck me. What do I do? So, you first you get well and you try to get out of the hospital. And that may be more than 30 days. It depends on what's going on. I mean, I guess, attending to your health is important and far more important than trying to figure out the insurance code of a particular vehicle. So that clearly, in those instances where the injuries are severe and protracted and extend for a period of time, that is definitely a circumstance that would permit a tolling or an extension of the 30 days. The filing of, bills, similarly, if a healthcare provider does not or cannot identify the insurance company for whatever reasons, if they're reasonable, they will be excused and the 45 days will be extended. I just yesterday did a case where, we did a brief search of recent arbitration awards. Not that many 45 days were extended, which, my case yesterday was on a billing company failure to actually get the bills out, and their excuse was that that the bills were in a bin, a mail bin going out. Instead of those bills going out for the mail, they went into a recycling bin and were actually trashed. And when they figured out their mistake several months later, that was the excuse. I don't have a decision on that case. It was heard yesterday. But there are various situations that could provide for the tolling of the 30 days for the filing of the no-fault application. Sometimes you may have the wrong carrier. The police report may have listed a code. You send it out to, Geico, and Geico responds, after the 30 days and says, hey, look, this is not our insured. You may want to check with State Farm or Allstate. And, and there's a little hunting that goes around, and we figure out who the proper insurance carrier is. And, that could also afford a reasonable excuse. So those statute of limitations, very short filing statutes, have to be looked at carefully when you are representing someone who's been injured in a car accident and need to get the no-fault application in within the 30 days and should get those doctor bills in within the 45 days of the date of treatment. Part of the admonishments that are contained within the no-fault scheme, I love this. The insurers, the no-fault carriers, are supposed to take a non-adversarial approach. That's written into the regs, and the claim practice principles to be followed by all insurers. And this is part of the outline that we've submitted here for the course today. The claim practice principles: A basic goal is to promptly and fairly pay all automobile accident victims. B, assist the applicant in the processing of a claim. C, do not demand verification of the facts unless there are good reasons to do so. When verification of facts is necessary, it should be done as expeditiously as possible. D, hasten the processing of a claim through the use of a telephone whenever it is possible to do so. I chuckle because it is rare. I really haven't even seen it where a claim rep will call up and say, hey, could you tell me what you meant when you submitted this particular bill? You have it under this particular code, and could you just clarify that? Because we'd like to adhere to these claim principles and pay these claims fairly and promptly. The truth of the matter is that the insurance carriers, in my experience, practice claim avoidance rather than the prompt payment of these claims. And although to me, common sense, I'd rather not sustain a 2% a month penalty and an attorney's fee, it doesn't seem to deter the insurance carriers. So what we'll see from the carriers is instead, they have to do, let me back up a little bit. Once a bill is submitted to an insurance carrier, they must do one of three things. They must pay it, delay it, pay, delay, or deny within the 30 days. So denials are sometimes issued within 30 days. Many of the times, that just gives us a 15-minute warning for the first part of our presentation. So I'm just going to kind of wrap up the no-fault overview. The usual, what we see normally is when a bill comes in, there'll be some delay that's provided where a carrier will send out a letter saying, could you submit A, B, or C to further clarify this claim. It's also known as a verification request. And we'll go into verification, and the most tedious verification would be the request for examinations under oath, and we'll talk about that a little later in the program. But what the point that I was trying to get across in the no-fault scheme in general and the brief overview here is that this was a regulatory scheme that was written with injured parties in mind, directing insurance carriers to promptly and expeditiously pay for health-related claims and lost wages that are related to a car accident. This doesn't happen voluntarily at a high rate. It's usually through the process of arbitration or civil litigation. There was a backup in the civil litigation for many years, some of which has been cleared up now. We just recently filed in civil court where there used to be quite a big backup. We are mostly in the arbitration. The American Arbitration Association is the tribunal that processes these claims. So if something is denied in 30 days and we want to contest that as a wrongful denial, we will file with a $40 filing fee a case with the American Arbitration Association. So with that, I'm going to transition to filing a successful no-fault arbitration and overcoming some common defenses. So I'm going to turn the program over to Michael Licatesi at this point.
Michael Licatesi here. I'd like to start off by saying that Tony was humble in his introduction, and hearing from him, myself, it is, invaluable. And for you all, I just want to stress that he is the pioneer in the industry. He humbly stated that we are no-fault arbitration attorneys. However, he is probably the most well-rounded and well-respected no-fault arbitration attorney there is in the industry. We're both trial attorneys. We do personal injury as well. I'm on trial right now. I was actually arguing some no-fault regs at my trial, my personal injury trial, so it came into handy. But I wanted to start off by saying that. To talk about the arbitration filing and to pick up where Tony left off, I didn't want to stop him, while he was speaking earlier, but both of our lectures today kind of cross paths. On the screen, you'll see filing the perfect case. Number one there is assignment of benefits signed by the patient and the healthcare provider. Tony alluded to that earlier. It's essential, and our firm does not file an arbitration without an assignment of benefits form. It's required, and we will not be able to get a provider paid unless that is included. We need responses to verification requests. Tony alluded to how important it is to respond to a verification request in the 120 days that you have. We need some type of response. So if the insurance carrier is looking for the scope or an MRI to verify the medical necessity of a surgery, you must send the scope, the MRI, whatever diagnostic tests that they're requesting to the carrier to make sure that they can verify that surgery. We need copies of the NF2, copies of the NF3 that Tony also mentioned. The medical reports, the narratives, the reevals, I can't stress enough how important the reevaluations are. If you're a physical therapist, acupuncturist, chiropractor, doing a reevaluation every single month is so beyond important because that's what we use to rebut an independent medical exam. And that's the next part of the lecture that I'm going to touch on as well. Results of diagnostic testing, progress notes, medical reports from outside medical referrals. That's usually where we run into some issues as well. Medical providers often have difficulty getting medical records from outside providers. However, we stress the importance to our clients that getting the entire history of this particular patient and all of the medical reports is beyond important. Getting us the MRIs, the referrals from the orthopedists. If you're a chiropractor, getting us the physical therapy notes, if they're doing PT and acupuncture as well. If they're receiving injections, getting injections. Having a full history and medical record is extremely important for us when going to arbitration. The last one here that we request is independent medical exams and peer reviews. Once we get the independent medical exam, we'll check to see if there's contemporaneous records. That's our main defense. That's what the arbitrator is going to look for as soon as the hearing starts, to see if there are any contemporaneous records. If there's not contemporaneous records, it's our job to then request it from the provider, figure out who has contemporaneous records to make sure that we can rebut that denial. The next is the peer review. When we get that peer review, we'll take a look at it, make sure that it's proper. If it is, then we'll get a rebuttal right away and upload that to the AAA ECF to make sure that we have a proper defense. I'd like to stop here on filing the perfect defense and just filing the perfect case and just emphasize how important it is to have a billing company. A lot of what Tony alluded to earlier referred to filing within the proper time frame, getting an NF2 within 30 days, getting in your bills within 45 days. If you're the best surgeon in New York, or if your client is one of the best well-known chiropractors there is in the area, it won't matter unless you have an organized billing company that can make sure that the bills get done in time, get sent in time, and they keep a log. It's important to make sure that proof of mailing is kept, that when everything gets sent out, they have a proper system in place that keeps track. Because if we need to go back to them in a year, 2 years, 3 years, or however long it is, they need to have personal knowledge of exactly what their procedures are, what was sent out, when it was sent out, who it was sent to, with the addresses stamped in a proper record, so we can come back to that later on and say, hey, they did receive this. Because when there is proof of mailing, it's the applicant's burden to show that they sent it certified. Then once we can prove that it was sent certified mail, that creates a presumption that the insurer received it. Whether or not we can prove they actually received it or not, they then have to overcome that presumption. Next topic that I'd like to discuss is independent medical exams. We included an independent medical exam here for reference. The first thing that I look at when looking at an independent medical exam is the date. Once I take a look at the date, then I can check the record for any contemporaneous records. As I mentioned earlier, contemporaneous records are a month before or a month after the independent medical exam. If you think about it logically, the reason why it is so important is because we need something to rebut that independent medical exam to say, hey, there actually were range of motion deficits. There actually were tenderness upon palpation in certain body parts. In the independent medical exam, and I'll scroll to it now, and it's properly redacted. That's why there are some blanks there. You'll see it's a PM&R, an acupuncture, independent medical exam. The next thing that I look at is what records did they review. Here on the IME, you'll see they only reviewed the NF2 and the police report. So it's a rhetorical question because they didn't even review any medical records. And oftentimes they won't. So it's extremely important to look at the date, check on contemporaneous records, and then look to see what they reviewed. If they didn't review anything, that's one of your first arguments that you say to the arbitrator, how could this be a fair medical exam if they didn't look at any of the medical records? And some of the arguments that I'll make is, if I go to an orthopedist, the first thing that they say on the phone to me is, please bring any of the diagnostic tests. Please bring an MRI. And if you have the film, that would be great. Please bring that too. These independent medical exams aren't asking for films or any other reports. And, if they do, they don't follow up for them. So if they're not looking at it, they can't do a proper evaluation. They don't know what the injuries are when they see them. Other important notes on the independent medical exam are to thoroughly look through the findings, see if there is any tenderness on palpation. If there is any tenderness, it's also our argument that the no-fault regs were put into place to make each individual patient whole. They are entitled to a full recovery. The IME doctors will get cute and they'll put in mild tenderness. Even if there's mild tenderness, they're still entitled to a full recovery. But besides that, they also do range of motion testing. 99% of these independent medical exams, you'll see perfect range of motion testing. Just make sure they're doing the proper range of motion, based upon the 5th edition of the AMA guidelines. There are better range of motion testing that has come out with the advancement of technology, like dual inclinometry. For the sake of time, we won't get into it today. Next thing I look at is the diagnosis. Here, you'll see, just upon many IMEs, the diagnosis is a sprain strain resolved. But if they reviewed the IME, they viewed the MRIs, I'm sure they would see that there were herniations, bulges, if there was an EMG, radiculopathy, or any tears. Here they evaluated the shoulder and the knee. Was there a tear or not? Then the diagnosis wouldn't be tendonitis. They're just changing the diagnosis, and it's important to note. One of the last things that I look at here are the what are they specifically denying? And if you're a chiropractor, if your client's a chiropractor and it's an orthopedic IME and they deny physical therapy and household help and any durable medical equipment, they're not denying chiropractic treatment. It's a case called Cerrucci that you bring up at the hearing, and you make sure that the arbitrator knows that they didn't deny the specific specialty that my client is treating them on. One other note on IMEs is if they do review medical records, if they do actually review the medical records, there's a case called Wagner that it is on the carriers to upload the medical records that the independent medical examiner reviewed or the peer-reviewed doctor reviewed. Otherwise, it's not a fair arbitration. It couldn't possibly be fair if a medical provider is a chiropractor and he doesn't have the PT and the ACU and the pain management records that the carrier has, and we sit at an arbitration, we're at a disadvantage. So it's important to also note that if they don't upload the records. There are many carriers that don't upload them, so I do mention it at most hearings. In reference to the peer review, this is a redacted peer review referring to an EMG. If you look through this peer review specifically, there's a slew of medical records here: physical therapy, CTs, x-rays, pain management, operative reports, durable medical equipment, and then you'll see a one-page discussion. Oftentimes what you'll see is a peer review with a laundry list of documents, medical records reviewed that they probably didn't look at, and then a one-page discussion. The reason why I say they probably didn't look at it is because the discussion does not line up with what they reviewed. And in this particular case, every time there's an EMG, Tony and I could probably tell you what the denial will be. Let's say there's no evidence of differential diagnosis, that you don't use an EMG just to rule out radiculopathy. There's no proof that they were going to change the treatment plan. However, our arguments on these peer reviews is, one, we make sure that we have a rebuttal. We upload the rebuttal that directly rebuts the peer. Each individual argument that the peer review makes will be rebutted by our doctor, or the treating physician, I mean. And they'll say, there are neurological findings, because the peer review will most of the time say there are no neurological findings. But throughout the record, there's numbness, tingling, radiating pain, weakness, with a whole slew of positive neurological findings, and the peer review doctor will say there are none. So the rebuttal will lay that out for them. Then in terms of differential diagnosis, it's important for your client to make sure that they put in there that the reason that they're doing this exam, if it's true, is to rule out neuropathy and radiculopathy, and to see what the actual diagnosis is. And they'll do the EMG, and a lot of the times the peer reviewer will be confident that that it's radiculopathy, all signs indicate radiculopathy, and then in fact the EMG shows neuropathy. So without the EMG, it's very difficult to tell what the exact I'm sorry, I think my screen stopped sharing. But here is the peer review. Where was I? It's important when you're arguing one of these cases, and it's important for a medical provider to be able to diagnose specifically where the origin of pain is, what type of pain, what type of injury is it. Is it nerve-related? Is it soft tissue injury? After the patient's been treating for 3-4 months, it's extremely important to figure out exactly what the injury is. From there, I'm going to pass it back over to Tony to continue. I apologize if my screen stopped sharing for a bit there, but I will scroll to EUO for Tony.
So I think Michael was quite kind by referring to the insurance doctors as independent medical examiners. You will not hear me use that term during an arbitration hearing because I do not believe that they are independent. Although insurance carriers put a wall between themselves and the patient, the EIP, the eligible injured party, by scheduling these examinations through a liaison or an intermediary. These intermediaries are paid for by the insurance carriers, and the doctors are essentially indirectly paid by the carriers. They are insurance doctors that routinely deny benefits. And it's incredible to me that they will find these perfect ranges of motion when there are documented injuries, when there are very objective findings through MRIs, CAT scans, EMGs, tests that cannot be manipulated, that clearly and objectively show injuries that are routinely ignored by those examining insurance doctors and downplayed. It's incredible to me. So that's my 2 cents on the term IME, which I don't use. Also, there is a seminal case called Taormina versus Goodman that it stands for this proposition: the doctor who examines must be of the same specialty of the treating doctor, and that's important to look at. So the topic that we're transitioning into is back to the verification process and the examinations under oath. It was added to the regulation that an insurance carrier has the right to request an examination under oath, either of the EIP, the eligible injured party, or the treating healthcare provider. And it's supposed to be for the purpose of verifying a claim. So usually when they ask a healthcare provider to leave his practice or her practice of medicine and answer these questions, it should be specifically on a claim. Most of the time, the carriers go on what I term to be a fishing expedition to try to see if they can avoid paying the claim by just hurling question after question regarding the corporate structure, regarding the staff, how the staff is paid. They try to ask questions, financial questions, and what portion of the practice is devoted to no fault and what portion is devoted to other areas. So it's basically, again, a fishing expedition. And what we do is we'll sit with the healthcare provider and we'll prepare that healthcare provider for this inquiry. And as the attorney that's sitting there representing the healthcare provider, it's important for us to protect our clients from these insurance carriers that are crossing the line and going beyond the verification of a claim. Very, very important. I have sat in hundreds, if not thousands, of these over the years now, and I stop the carrier and I remind, whether it's an attorney, a rep, or an SIU investigator, I remind them that we are here to cooperate. We are here to crystallize or clarify that particular claim that was submitted. And we're not here to give, the doctor's history of the practice of medicine. And they routinely try to do that, where they'll start with, what year did you come out of medical school, and take them from, the inception to the current time, which is really inappropriate, unless they make some showing of why it would be relevant. Are they claiming that the doctor is not licensed, the doctor did not go to school? There should be some showing by the insurance carrier as to why they need to pursue this course of questioning of a healthcare provider. So if a healthcare provider submits a bill for an EMG, the questions really should be, what was the medical necessity for the EMG? I have tomorrow, I was just reviewing a case for tomorrow, and the peer reviewer, the insurance doctor paid for by the insurance company, in his peer review states that the EMG was not used to establish the necessity for surgery. Well, an EMG is really a test designed to show exactly where the nerve root irritation is. It shows a differential diagnosis, let's say a radiculopathy versus a neuropathy or myopathy. The literature really does not support that statement. And it's quite an irresponsible statement, because, treating doctors have an absolute right to find out specifically where the injury is located. Although an MRI will give the general location, a nerve root irritation that specifies exactly which nerve root is affected will help that particular doctor, maybe with an injection, maybe with more aggressive physical therapy, or, hey, we want to lay off that area because it's an extreme or chronic condition. So, if you and I were being treated, we'd want to know that, and we'd want to know that information. But, like I said, they're insurance doctors. They're doing what they're paid for, which is really to help the insurance carrier avoid the payment of these claims. And, so we take them to arbitration and we fight them there. But my topic right now on the examinations under oath, in that particular situation, the submitting healthcare provider should be actually questioned. Hey, when you saw that patient, what were the current complaints? What was your examination? What led you to believe a month or two later, or whenever that the doctor indicated him for that particular procedure, what was your rationale? Why did you indicate him for that particular EMG or whatever the diagnostic test may be? But unfortunately, it's been my experience that, the EUO process, the examination under oath of the healthcare providers, is really an underhanded attempt to try to ascertain information to avoid payment of the no-fault claims. So there was a point in time that healthcare attorneys, not specializing in no-fault, would advise their clients, hey, don't go to the examination under oath. I think that's poor advice. If you do not attend that examination under oath, it will stop the payment of the no-fault claims and justify the non-payment of those claims. So if there is a request, it is provided for under Regulation 68, and the doctor not only should attend, must attend if he wants to get his bills paid. So that's really the part of the examination under oath on the healthcare provider. With regards to taking the examination under oath of a particular EIP, Many of the times, my experience in this area is that they're small percentages that they're really looking at the injured party. Was he really in this accident? The insurance carriers will tell you that fraud permeates throughout the industry. It is such a small percentage of these claims, the so-called staged accidents. There's one particular carrier, and I could say it by name, American Transit. They probably lead the insurance no-fault industry in denials, in verification requests, in a complete waste of time in an effort to avoid the payment of these claims. There are many doctors that don't even want to take an injured party, that they have to submit claims to American Transit because they're so difficult to deal with. And those verification requests and those examinations under oath, of not only the EIPs, the injured parties, but of the doctors are prevalent. And then the document requests, where they continue to ask for documents to further verify the claim. And they ask ad nauseum, but that's just one particular carrier. What I have found with the EIP examinations under oath is that they usually use that particular insured to try to ascertain information regarding the medical practice. Who treated you? Could you describe what he or she looked like? What did they do? To try to, again, avoid claim the payment of reasonable and necessary claims. A client, whether you're a personal injury attorney that has received an examination under oath of a client, you should produce that client, because the non-production and the failure to cooperate will result in a denial of those benefits. And you don't want to deny, those no-fault benefits, because they're so important to the injured party. And there are times that you can't make the first scheduled examination under oath. It should only be adjourned once, because after the second time, they can deny based on a failure to attend 2 scheduled examinations under oath. And the same goes for an independent medical exam. If you can't attend the first insurance doctor examination, please go to the second, because the failure to attend 2 scheduled exams will result in the denial of benefits.
If you're in a jurisdiction that requires a verification code, please write the following code word down. Toll. Toll. Toll.
So that's really my part on the EUOs, or the examinations under oath. The last part of our program today is some recent fee schedule changes that are currently in effect, and maybe, showing what we call a prima facie case.
Would you like to do a minute or two on Malela? I have it up, or you want to move on?
Well, the Malela case, sure. I mean, it's a case that's abused by insurance carriers. Malela was a case many years ago, when I first came out of law school, late 80s, early 90s, that had a particular doctor that was essentially renting out his license. He was what we call a doc in the box. He was renting out his license to other providers or to lay people, and they were using basically his medical license to bill for services that he was not controlling, not supervising, and was not in attendance. I mean, a doctor doesn't have to be at the office. Like a radiologist does not have to be at the MRI center reading that scan. He can do it through the computer, teleradiology. A medical director for a practice, as long as he is controlling and directing the practice, does not have to be physically present. But what Malela says is, hey, you can't rent out your license to a lay person or to other specialists and not be the controlling entity of that particular professional corporation. And what the insurance carriers have done in the Malela case, if you read it, admonishes insurance companies from broadening the scope of the finding in the directive in that particular case to apply to areas not that specific. And lo and behold, insurance carriers have done exactly that. They broadened it. They use it as a sword. Unfortunately, if there is what we call a declaratory judgment, where they're going into either a state or a federal court to have a judgment entered that the no-fault claim should not be paid, a declaratory judgment based on Malela, some sort of civil RICO suit, this effectively puts an economic stranglehold on the healthcare provider. And it's been my experience, the carriers have no intent on going even to the discovery deposition stage of these cases. They like to delay it a year or two, which really prevents the healthcare providers from billing and from receiving payment of its bills, and puts this economic noose around the healthcare provider's neck and strangles them, financially. And unfortunately, that Malela case is abused. And it's an area of the law where insurance carriers have judges concerned when they start screaming fraud, fraud, fraud. Hey, there's something going on here. It's Malela, it's RICO. And it's an area where some of these healthcare providers are treated as if they were guilty and have to prove themselves innocent. It's a shame that this occurs. It's an abuse by the insurance companies. And again, when I started the program, I told you a little bit about Department of Financial Services and how the insurance lobbies kind of control who goes in there. If you look at those officials that run our DFS, they usually have some sort of lineage to insurance carriers, or they've responded inside of this particular area of law. So that's really all I have to say on Malela. If the attorneys are representing healthcare providers that need representation in an examination under oath, you can call us, you can contact us, the Licatesi Law Group, where you can easily reach us. I know we're going to give you some information at the end of this, but I'm going to switch it back to Michael on the prima facie case. And Michael, you had spoken about the billing and the NF3. The regulation calls for a prescribed form, which is the NF3. It is an invoice that should be submitted. However, a health claim form, known as the HCFA 1500, is the universal claim form and can be submitted by doctors when submitting an invoice for a no-fault claim. However, the NF3, if you look at box 16 and what's underneath box 16, 16 says that if the treating provider is different than the billing provider, so it can be ABC Medical that's submitting this bill. What box 16 is asking the healthcare practitioners to provide is, hey, who did the EMG? Who did the injection? Who did the physical therapy at that particular office? They want to know the treating provider's name, and that goes into 16. There is no such box on a HCFA 1500, the universal claim form. And that's why the providers, they like this. The insurance carriers like this. The providers, should have it in their computers and generate their bills on this form. If they use the 1500s, what'll happen is the insurance carriers will ask for a verification or a delay of their bill, and please submit this form, the NF3. So why not submit it from day one? If you scroll down after box 21, you'll see that any person who knowingly, with intent to defraud an insurance carrier, this is a fraud statement that the provider is affirming that they will not be perpetrating a fraud on the insurance carrier. So right underneath that statement is the provider's signature. And the owner of the PC should be signing in that box. And this is a prescribed form basically because of that fraud statement that's contained within that form. They want it on that so that if there is any improper billing or any, I don't want to use fraud, but if there's any impropriety, that they do have this language to go after the healthcare provider. So that's what I wanted to say on the NF3. Michael, if you want to touch on any recent fee schedule changes, now's your opportunity.
Yeah, so we only have a few minutes left, running a bit over on some of the other topics. We included a prima facie case here. I'll just mention it. It's up on the screen now. I think it's important because each, the applicant and respondent need to prove prima facie in order to move forward with the arbitration. Most important here is proving that there was a bill that was mailed timely with proof of mailing and using the proper form, putting the carrier on notice, something along the lines of an NF3 or the HICFA. Also, in this case, they address a mailing affidavit, which met the business exception rule to the hearsay rule. So it's important to know that, to read that. Also emphasizes the importance of a billing company that is extremely organized. If you read through the decision, that keeps a log of everything, had personal knowledge, and the mailing affidavit, along with their proof of mailing, which was certified by USPS, was enough to win this appellate case, which is controlling law that's important for everyone to read if they're looking to arbitrate or litigate in the no-fault arena. I'm scrolling down to some of the newer stuff. I'd like to point your attention to some of the New York fee schedule changes. This is towards the end. Important, briefly, our MUAs for chiropractors are out of the fee schedule starting in October 1st, 2020. If you're in the industry, you'll hear many providers speak about October 1st, 2020. Every so often, there will be changes to the fee schedule. So although that's a knock to chiropractors and sometimes they get the short end of the stick, their reimbursement went up significantly. They were getting $46.24 a day for treating a specific patient. That went up 3 times to roughly $114. So their reimbursement per day went up. Physical therapists went up as well. They were making $67.60 a day. Now they're up almost to around $125. So along with the increase in reimbursement rates, there was one other change that I'll mention I believe is important. I won't go into all of them, is the RVU difference. So now acupuncture, physical medicine, so PT and chiropractic all fall under the same umbrella, and they're all under the same RVU. So you can only do 12 RVUs for each individual specialty. So there were multi-specialty facilities that had PT, Acu, Chiro in the same facility, doing them on the same day. That's no longer allowed, and it changed the dynamic of multi-specialty facilities because they had to kick out acupuncturists or do whatever they felt necessary to increase their revenue after these changes. The RVUs go up to 15 when including reevaluations, which I emphasized earlier, and then 18 RVUs with the initials. Tony and I included some recent changes or recent statistics that I think is important, because if you speak about no fault to someone that's not in our industry, it's not a very well-known field, and it's a very niche industry. But if you look at the numbers here, based upon 2020 numbers, there were $817 million worth of cases filed in just 2020. That's 357,000 cases and 357,435 cases. Sorry, it's a pretty big number, especially when you think about an industry that's not, so well known. From 2015 to 2020, that's a 70% jump. So the industry is increasing. It could be a lucrative industry if you know what you're doing from the applicant side, and respondents will remain busy. Here, the number of filings broken up by area, Tony and I are here in Garden City in Nassau County. Surprisingly enough, there was 201,000 filings, more than any other area. And if you see on this third page here, number of arbitrators went down from 186 to 182. The reason why that's important is it's important to know who you're presenting in front of. From an applicant, in a claimant perspective, it's important to know what that arbitrator follows. Do they follow Westchester? Do they follow Rocket Docket? What specific case law do they follow? And who are you appearing in front of? There's only 182 arbitrators. The chances are you're going to appear before most of them. And it's an important thing to keep in mind. Here there's master appeals. If Tony and I feel strongly about a case that we may have lost, we will appeal it. We will spend, as much time as it possibly takes to draft up an excellent appeal and then hopefully get it remanded to a different arbitrator. But if it gets remanded to the same arbitrator, we present our arguments again and hopefully are successful the next time around. But as Tony mentioned, we do have an extremely high success level, so it doesn't happen too often. But that's our lecture for today. I don't know if there's anything else Tony wants to mention, but if you need to reach out to me, I'm always available. My cell phone is 516-659-2058, 516-659-2058. Our office line here is 516-227-2662, 516-227-2662. You can ask to speak to Anthony or myself, or we have a staff here of personal injury attorneys, paralegals, clerks, and no-fault arbitration attorneys and data inputters. My email is M as in Michael, my last name, at tllgllp.com. Again, it's M Licatesi at tllgllp.com. Tony?
Yeah, my contact would be similarly A Licatesi, ALICATESI at tllgllp.com. And my direct line here at the office is 516-478-0210, 516-478-0210. That goes directly to me, bypasses the receptionist. If any of the attorneys have questions on this area, please call us. If you have a personal injury practice and you're looking to reduce the amount of the lien and you need us to place the unpaid medical expenses into arbitration, we'll be happy to do it at no cost to you. We will also file for your injured parties' lost wage claims. I do not see any questions on the chat. We were leaving a few minutes at the end for any questions, but that really concludes our program for today on New York State no-fault laws and Regulation 68.
Yeah, if there's any personal injury attorneys or there's any no-fault arbitration attorneys or even, adjusters, claims reps, carriers, defense attorneys that need a brief, if they need anything on the personal injury side as well, a complaint that we've drafted, feel free to reach out. Any advice, I'd be more than happy to. I lecture and teach many young attorneys and help them advance their career. As Tony's been recognized as one of the top attorneys and trial attorneys in New York, I've learned from the best here, and I'd be happy to share my wealth of knowledge that I've learned from him and pass it on. It would be my pleasure. Thank you all.